You all set, Austin?
We should be. I'm just checking the stream right quick to make sure we're up. We are live.
Okay, real good. Thank you. Okay, at this time, we'll have a virtual special board meeting of the Board of Education. And it's September 21st, 2020. Matt, can we do roll call, sir?
Yes, sir, Jim. Stephen Gunther.
Here.
Amber Cochran.
Here.
Jim Barry.
Here.
Malik Saif.
Here.
Matt Rader here. Mike Colmorgan. Absent. Alex Antosky. Absent. We have a quorum, Jim.
Thank you very much. Okay, I need a motion to approve the agenda as presented. Do I have a motion?
I'll make the motion.
Steve,
Okay,
you make the motion?
Then I'll second it.
And Matt seconded it. Any additions or deletions, Kim?
Nope, the agenda
Okay.
stands as it is.
Okay, roll call, please.
Stephen Gunther.
Yeah.
Amber Cochran.
Yeah.
Jim Barry.
Yes.
Malik Saif.
Yes.
Matt Rader. Yes.
Okay, thank you, everybody. Okay, now we go down to new business, approval of purchase of 100 Dell Latitude 5400 devices. Support staff purchase from this state approved contract with an amount of $90,801. Austin, you're on.
All right, so this purchase is a little bit different. It's not off of the RIMSI contract. Nothing on the RIMSI contract was available. This is off of another state contract that we have done the research to make sure that we're allowed to use. It's the best price we were able to get on devices that might be in sometime relatively soon. We hope to get those here in the next week or so.
Okay, do I have a motion to accept? Do I have a motion? Matt?
I'll make that motion.
Amber, do I have a support?
Support.
Okay, we have a support. Any further discussion?
So I got a question for Kim. So
Absolutely.
Kim, so obviously for the interim time, the parapros and the support staff are working from home as well. When we go back, whenever we decide to go back full face-to-face, would the support staff still maintain these laptops or no?
Yes, they will, because
Okay.
we do not know, even if we go back, when we go back, if we will remain back, unless there is a vaccine that most of our staff and students take. It's questionable of whether or not when we go back, we'll be able to stay in. So rather than, take them away, give them back, they will maintain them, as will the students, but the students will bring theirs to school with them so that they can work on them at school as well.
Right. So I'm thinking 5 years out from now, will we be replacing these ones for the support staff?
That's
So,
a good question, Matt. It depends on whether or not, what the state of affairs is. I think we'll always have some online learning. It might not be to the extent that we do now, but talk about say there will no longer ever be a snow day again.
Correct.
Because there won't need to be, So,
Right.
we probably will continue to be a digital environment from here on in.
Okay. So Austin, I know you have that great sheet that has all the laptops, how often we have to replace them. When we get these, can you add those? Maybe it might not be 100, I guess, but it might be 50, 75 down the road.
So 72 is the magic number for right this moment. Obviously, that changes some. We already, you guys had approved a purchase of Chromebooks for them. The problem with the Chromebooks are we cannot get them right now. For a lot of our support staff, that would be sufficient for what they need, and they're already in that plan.
Okay. All
Real
right.
good?
Thank you. Yep.
Anybody else have questions? Hearing none, roll call, Matt.
Stephen Gunther,
Yeah.
Amber Cochran,
Yes.
Jim Barry,
Yes.
Malik Saif,
Yes.
Matt Rader. Yes.
And Austin, how soon will we get those? You and I talked about it.
Ship date is the 25th, I believe.
Yeah.
So we should hopefully have them here in the next week.
Cool. All right. Thank you, everybody. Okay, now we go on to our presentation with our attorney, Mr. Foley. Mr. Foley gave a nice presentation to the staff about the COVID-19 law. I think it's important that you guys all understand the law as well. So at this time, I'll turn it over to Kevin. Kevin?
Thanks, Jim. Yeah, as Jim said, back in the late August, we talked with staff. A lot's changed since then, and quite frankly, very little's changed since then. I think that there's probably a little less apprehension from staff and from folks, but it's still unknown of what we're doing, where we're going, how long we're going to be, where we're at. Tonight, I'd like to talk about the 4 areas of law or orders that impact our employees specifically, and some that impact our students as well. The first is the American with Disabilities Act, the ADA. You've all heard of that. It's been around for a long time. The Family Medical Leave Act, which has also been with us since the 90s. And then we've got some new laws that were passed in March, became effective in April of this year. That's the Families First Coronavirus Response Act, or the FFCRA. That legislation actually has 2 different areas of law that it covers. The first is the Emergency Family Medical Act, and the second is the Emergency Paid Leave Act. So we'll get into both of those just briefly. Finally, we're going to talk about some of the governor's executive orders. I think as of yesterday, there were 181 of those since March. You'll be pleased to know I'm not going to cover any of those in great detail, so you don't have to slosh through that. But we will talk about them a bit. If you have any questions, I don't know if you want to hold them to the end, if you want to jump up, whatever you folks prefer is fine. And I will tell you, and as I told the teachers, the State Court Administrative Office has picked Zoom for all court hearings, and that's also how we do depositions. So I'm really terrible at this Google stuff. The only place I use it is here. So every so often my camera won't be on and I sound silly. That's me, not the computer, but I try to do the Google stuff for you. Now, the ADA, over the last 6 months, since March, of course, the most questions have been on the issues relative to the Americans with Disability Act. The ADA, as you probably well know, makes it illegal to discriminate against qualified employees with handicaps as long as they can do the position that they're hired to do. You can't discriminate against them because of their disabilities. Now, it also requires employers, the district, and its employees to engage something called the interactive process to determine if reasonable accommodations can be found. Now, the process is kind of a give and take where the employer, the employee's doctor will issue a note that says this person needs this accommodation to be effective at work. It might be work from home. It might be, I've had them over the years, air conditioners, filtration, other things. And part of the process is then the district would say, well, we think that if we did this, that would take care of the problem. And so there's this back and forth until at some point, either an accommodation can be determined or the district just says no, that we can't accommodate, that either what you're asking for is unreasonable, it's either unreasonable because it doesn't help you to do your duties, or it's cost prohibitive, or quite frankly, it makes it so you can't fulfill your duties to the district. Now, generally, as we all know, COVID-19 is a virus. Viruses are not covered under the Americans with Disabilities Act because a virus is not considered a disability. Now, that being said, the fact that an employee, and this is what we usually get, the employee comes up, we get a doctor's note, the employee is over 60 years old, they have an increased risk, and they want an accommodation. Being over 60 years old is not a disability. It's not going to get you an accommodation under the Americans with Disabilities Act. Likewise, the fact that you care for either an elderly parent or you have children with autoimmune diseases Once again, that is not a disability under the ADA. And I think as parents and as children, we appreciate the fact that people are worried about either their kids that live with them or their parents that live with them. But quite frankly, that is not a disability and is not covered under the ADA. Now, this usually, we get these questions when an employee with a disability wants to telework or work remotely without coming into the building because of their increased health risk. And I know that we've had a couple of those with MelNAP. I've had dozens of them with my other districts. You know, teleworking certainly is an accommodation, but it's not the only accommodation. So once again, you need to enter into the interactive process. I know I've had districts that, in that case, we've offered an early start for these employees so that they don't get, you know, in that bottleneck at the desk when they're doing their tests. We've allowed more filtration, more spacing. We've done some plastic shields for these folks. We've offered K95 masks rather than the regular throwaways. You know, this is all part of the interactive process, and quite frankly, so far we've been quite successful in getting folks to come to work that need to be at work. Going further with the ADA, if an employee calls off sick, the district can inquire as to why they were sick. This is different for COVID-19 with all the other maladies that folks call off on. That is usually a prohibited subject. It's not the employer's concern as long as they don't stack 3 or 4 days and you request a doctor's excuse. But according to the EEOC, that yes, we can require the employee to tell us what they were sick or at least what their symptoms were so we can determine whether or not it could have been COVID-19 so that we can, quite frankly, try to protect all our employees and our kids. The EEOC also tells us that the district can require a return to work doctor's note from any employee that has been away from work. Now, they don't define what away from work is, and I think that we will probably see through cases and EEOC determinations and regulations what that means. But for now, once again, you can ask someone why they're gone. If they indicate that they did have symptoms that look like COVID-19, then you can make them get a doctor's note to tell us that they're fit for duty. Finally, as I indicated before, an employee who does not have a disability is not entitled to an accommodation because their spouse, child, or parent is at a higher risk of severe illness from COVID-19. Is that fair? Probably not, but that's what the law is. In summary, the ADA, and you know, quite frankly, folks, this isn't new. I tell my clients that COVID-19 is new. The ADA has been around since 1990. The difference is that we're trying to make the square pandemic fit in the round hole of the ADA and try to make everything make sense. I think the good thing about the ADA is it does force the parties, both the district and the employee's doctor, to really come together and try to figure out what's best for the employee, what's best for the employer, and try to make it work for everyone. So, quite frankly, as long as we're attempting resolutions, we're well within the requirements, and hopefully the resolution can come to pass. The second area of law, or the second law, is the FMLA. Once again, this was enacted in 1993, been around a very long time. As you probably know, it allows full-time employees up to 12 weeks of unpaid job protected leave to care for a spouse, a child, or if they have their own serious health condition. Excuse me. Now, a serious health condition generally requires either an inpatient hospitalization or ongoing care that you treat with a doctor on an ongoing weekly, bi-weekly manner. COVID-19, like having the flu, is not sufficient in and of itself. Certainly, we know that there are cases of COVID-19 that are very severe, that do cause hospitalization. And for those cases, certainly FMLA comes into pass. But COVID-19 may constitute a serious health impairment or health condition to meet the FMLA requirements if it exacerbates or really contributes to another serious health condition. So someone who has, there's many autoimmune diseases and COPD and things that are exacerbated by COVID-19, that COVID-19 wouldn't get the FMLA with the underlying condition it does. Having a fear of contracting COVID-19 doesn't qualify for the FMLA. We hear that again and again, that I'm either in this high risk, my kid's high risk, my parents are high risk. Sorry, it doesn't apply. Now, the FMLA also provides for intermittent leave when same is required for the serious health condition. That includes if you have to drive your kid or your spouse to see the doctor. You go to see the cardiologist every Tuesday. Those folks can work half a day, take half a day off, do what they need to do. Like I said, it's a total of 12 weeks. It's a rolling period, so you get 12 weeks every year. You do have to have 1,450 hours in the previous year to get the entitlement. So while our full-time folks are probably entitled to it, most of the part-time folks won't get those hours in. In MelNAP, I understand that the FMLA leave is filed through a third-party service provider. We provide the forms, the people file the forms with the service provider. They then report to us the status. Once again, I think that everyone is taking a good hard look at every leave request, whether it's an ADA situation or an FMLA situation, because they've just compounded. Getting, quite frankly, here I'm getting a dozen a week for my clients, and quite frankly, most of them are doing it on their own. So I don't even see the vast numbers that they have. Does anyone have a question on either of those two? Because that's kind of old law. Those have been around for a very long time. It's not rocket science.
Anybody have any questions? Steve, Malik, Amber, Matt? Okay, we'll continue on. Thanks, Kevin. Continue on.
All right, let's go. The new laws is basically the FFCRA, which is the Families First Coronavirus Response Act. And that act contains two different laws. The first is the Emergency Paid Sick Leave Act, and the second is the Emergency Family and Medical Leave Expansion Act. Quite frankly, this legislation was passed on March 18th of this year, became effective on April 1st of this year, and is set to expire on December 31st of this year. I would imagine, given the reality of COVID-19, that it will be extended. I don't see a cure between now and then. And I think, quite frankly, what's going to happen is the Fed is going to roll over all the benefits at the start of the new year. That's my guess. I have no crystal ball. Depending on what happens in the election, I could be totally wrong. But right now, it's set to expire at the end of the year. The first part of that is the Emergency Paid Sick Leave Act, and we've all, I think, heard about that. That gives each full-time employee 2 weeks or 80 hours of paid sick leave if the employee is unable to work for one of 6 qualifying reasons. And quite frankly, for part-time folks, they get 2 weeks of leave, but it is reduced as a portion of what they work. So if they're half-time, they would get 40 hours over 2 weeks. Once again, this is paid sick time. Benefits remain if they have benefits. Now, the stated reasons for the paid sick leave is if the employee is subject to federal, state, or local quarantine or is in an isolation order related to COVID-19. Quite frankly, we've not have one of those yet. We have certainly had recommendations, stay-at-home orders, but that is not a quarantine or isolation order.